Hello, everyone. Welcome to the U.S. Immigration News. In a time when immigration headlines are often filled with fear and setbacks, today's update brings something different, some long overdue good news. Whether you're an applicant, a family member waiting for a loved one, or just someone hoping for signs of progress, this one's for you. Across the country, there are meaningful signs of change. Communities standing up for their rights, faster decisions from USCIS, and new policies that could actually offer real help to immigrant workers. It's not perfect, it never is. But today, we get to focus on what's going right in the immigration system, and that matters. In this video, we'll break down the legal wins happening at the local level, a surprising improvement in USCIS processing times, and a new federal visa initiative that could help thousands of workers who've been left out for too long. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Let's begin in Los Angeles, a city that has long stood as a defender of immigrant communities. But this time, LA isn't just pushing policy or issuing statements. It's going to court. In a sweeping class action lawsuit, the city of Los Angeles has accused U.S. Immigration and Customs Enforcement of violating the Constitution in how it conducts immigration raids. The lawsuit alleges that IC officers have detained not only undocumented immigrants, but also green card holders and even U.S. citizens based purely on appearance. Legal advocates are calling it racial profiling. And what makes this lawsuit different is that LA isn't fighting just for its own residents. It's asking the courts to certify the case as a nationwide class action, one that could force a federal reckoning over how IC does its job. The claims are anchored in two of the Constitution's most powerful protections. First, the Fourth Amendment, the right to be free from unlawful searches and seizures. And second, the Fifth Amendment, the right to due process and legal counsel. According to the complaint, ICE officers have routinely ignored both. But LA's fight doesn't end in the courtroom. The City Council and LA County supervisors are exploring new local laws to shield residents from what they see as unconstitutional federal enforcement. They're reviewing policies to limit cooperation with ICE, expand legal aid, and increase transparency when arrests happen. While the legal battle plays out, another surprising development is unfolding behind the scenes, one that could reshape how the US treats essential workers who are undocumented. In quiet conversations in Washington, officials are drafting a new category of temporary visa, informally called the temporary pass. This proposed visa would allow undocumented individuals working in key industries, agriculture, construction, restaurant work, and even car washes, to legally live and work in the US, at least temporarily. The logic is simple. The US economy relies on these workers. They're already doing the jobs. So rather than turn a blind eye or threaten deportation, this visa would offer a form of legal acknowledgement and protection. While full details haven't been released, immigrant advocates are hopeful. It may not be permanent status, but it's a step toward dignity and safety for thousands of people who have kept America running from behind the scenes. And then there's the news no one saw coming. USCIS is speeding up. Yes, you heard that right. After years of record backlogs, delays, and radio silence from the agency, applicants are suddenly reporting shockingly fast turnaround times. One recent applicant for U.S. citizenship, filing Form N-400, reported receiving their interview appointment just 2 weeks after filing. Adjustment of status cases are also moving more quickly, and even employment-based green card applications are seeing signs of life. Immigration attorneys across the country are urging their clients to file now, while the window is open. There's no guarantee how long this pace will last. But for the first time in a long time, there's real hope that cases might actually move. That said, it's not all good news. There are still major shifts happening on the enforcement side, and they could cost families everything if they're not careful. On July the 4th, President Trump signed into law H.R. 1, known informally as One Big, Beautiful Bill. It's a sweeping immigration enforcement package passed via budget reconciliation, directing over $170 billion toward border and interior enforcement over 4 years. The law expands militarized zones across 1/3 of the US-Mexico border. It authorizes soldiers to arrest people on immigration violations. It also raises fees across the board, from asylum applications to work permits. For example, beginning July 26, all asylum applications must now include a $100 fee, a major departure from past policy. USCIS will reject any applications postmarked after August 21st without the correct fees. And as if that weren't enough, the Trump administration has continued terminating temporary protected status, or TPS, for vulnerable countries. Haiti, Honduras, and Nicaragua are among the latest to lose TPS protections. For many families, this means the threat of deportation is once again looming, despite years of lawful presence and contribution to American society. Yet in one of the most significant rulings of the summer, the U.S. Supreme Court dealt a blow to state-level immigration crackdowns. Florida had passed a controversial law that made it a felony for undocumented immigrants to enter the state, even those with pending asylum or other protections. The law also required jail time without bond, but the Supreme Court refused to lift a federal block on the law, siding with lower court rulings that said immigration enforcement is a federal responsibility, not something states can police on their own. It's a major win for civil liberties and for the American Civil Liberties Union, which filed the challenge. The court reaffirmed a principle that's stood for over 150 years. Only the federal government can set and enforce immigration laws. The decision sends a clear message, not just to Florida, but to other states like Texas, Oklahoma, and Iowa, which are pursuing similar laws. Immigration is a national matter, not a local experiment. So where does all of this leave us? In some ways, more divided than ever. Enforcement is growing more aggressive. Fees are rising. Protections like TPS are vanishing. But in other ways, there are signs of real change in how cities like Los Angeles are standing up for immigrant rights, how new visa ideas are surfacing even under tough political conditions, and how federal courts are reminding states of the limits of their power. This is what the immigration landscape looks like in July 25. It's alive, shaped by the voices, votes, and courage of people on all sides of the system. The U.S. Immigration News channel provides all necessary visa information and procedures for your U.S. immigration journey. We'll continue to bring you updates on visitor visas like B1 and B2, work visas like L1 and H1B, student visas, green cards, including EB categories, and family immigration. Thank you for watching, and we'll see you in the next video.